Welcome everyone to today's Legal Epidemiology at Lunch webinar. Today, we will be talking about preemption, and we have some lovely guest speakers, which I'm going to quickly introduce to you all. Firstly, my name is Alex Hess. I'm the legal training manager at the center, and I will be moderating today's session. So we should have some time at the end, about 10 minutes after all of our speakers are done presenting, for questions. So please feel free to use the Q&A function. You can go ahead and ask questions throughout the session, and we should be able to get to those at the end. But first, we will be hearing from Amy Cook, Senior Legal Program Manager here at the center, who is also our State Preemption Laws Project Supervisor. She will be talking a little bit about what preemption is for those of you who may be unfamiliar or who need a little bit of a refresh. I know I always do. And then we'll be hearing from my other colleagues, Lauren Langen, Legal Program Manager here at the center as well, and Adam Herpelsheimer, Law and Policy Analyst. Both Lauren and Adam also worked on our state preemption laws project, and they'll be talking a little bit more about that. Then we'll hear from Ben Hartung, Public Policy Advisor at the Division of Chronic Disease and Injury Prevention at the Philadelphia Department of Public Health, on firearm regulation in Philadelphia and preemption related to that. And then finally, we'll hear from Brianne Schell, Public Health and Public Policy Lawyer at the Local Solutions Support Center, who will be talking a little bit more about some of the practical application of preemption law tracking. And then finally, we should have some time for questions. Again, at the end, please feel free to use the Q&A function to ask your questions, and we should have some time to get to those. All right, without further ado, I'm going to turn it over to Amy to talk a little bit more about what preemption is.
Thanks, Alex. Hi, everyone. Thanks for joining us today. So I'm just going to go over this very quickly because we have a pretty packed hour. So just briefly, what is preemption? Preemption is the legal doctrine that allows higher levels of government to limit or prevent a lower level of government from self-regulating in a particular area. Generally, it's kind of top down. So federal law preempts state law through the U.S. Constitution, the Supremacy Clause, and then similarly, when state law and local law conflict, the state law will control. Next slide, please, Alex. Okay, so how does this impact public health and local health departments? Health departments and local governments derive their powers from the state. So the ability of state governments to preempt local governments depends on several factors, and states can vary in how much authority they give to their local governments. So Dillon's rule is a stricter approach to local governance where localities only have the powers that are expressly granted by the states, and the scope of those powers are pretty narrowly construed. And then other states operate under home rule, so local governments have the ability to regulate in areas that aren't in conflict with state laws. But states actually vary in how they apply these approaches, and sometimes there can be variation within the same state. So, for example, some states have home rule apply to cities with a certain population over, for example, like 10,000 people, where Dillon's rule might apply in other cities or other municipalities. Next slide, please. Okay, so express preemption is when a state has a law that specifically and directly limits local authority. So there's different kinds of forms of express preemption. Floor preemption is when the state sets a law that sets a minimum and local governments cannot regulate below that, but are permitted to regulate above that state standard. So an example of that would be when a state sets a requirement that employers must provide, for example, 10 days of paid leave, but local governments are permitted to regulate and require employers to provide 15 days of paid leave. Ceiling preemption occurs when the local government is prohibited from enacting ordinances or laws that go beyond or differ from the state law. And this is kind of what the most common form of what people hear preemption, this is what they generally think of. And vacuum preemption occurs when a state will prohibit the local government from regulating in an area, but will not themselves enact a law or regulation, kind of leaving what we call a vacuum. So an example of this would be if a state prohibited a local government from passing a minimum wage law, but then the state did not set its own minimum wage law. And next slide, please. Okay, and sometimes there's no express language that prohibits a local government from enacting a law or regulating an area, but maybe the state law is unclear, or there is a municipality that enacts a law that's inconsistent with state statutes. So that's kind of implied. A court or an attorney general will sometimes find that preemption is implied. So this can happen when the laws conflict. So it's, for example, it would be impossible for to comply with both a state law and a local law, or when there's field preemption, when when a court would find that the state legislature intended to regulate the area comprehensively, or sometimes the state doesn't expressly prohibit the local government from doing something or acting in an area, but creates a lot of barriers that would make it functionally impossible for the local government to operate in the area. So one example or area of that would be municipal broadband. And that is just very, very fast, very quick overview of preemption. And if you have any follow-up questions, you can put them in the Q&A box. But now I'm going to turn it over to my colleagues, Lauren and Adam, who are going to go over our preemption law dataset.
Thanks, Amy. Hi, I am Lauren Langen, and I'm here with my colleague Adam Herpelsheimer to talk with you about our state preemption laws dataset, through which we track state preemption in health-related domains from 2019 to 2024. Next slide, please. So a quick roadmap of where we're going to be going in the next 15 minutes. I will talk with you about the domains our dataset covers, as well as the evolution of our project since 2019, and then some findings over time. And then Adam will jump in with some of the key highlights from our transgender rights domain specifically. Next slide, please. The original scope of this project examined express state-level preemption, meaning when a state law explicitly limited or restricted the lawmaking authority of local governments. The Center for Public Health Law Research, in partnership with the National League of Cities and funded by the Robert Wood Johnson Foundation, used the policy surveillance process to capture laws in the 12 legal domains listed on this slide across 50 states as of August 1st, 2019. Next slide, please. With this cross-sectional data set, the team was able to visualize preemption as of August 2019 at a high level. As you can see from this map, which was taken from the National League of Cities report on the data, here you can see that the darker blue correlates with preemptive state laws in more of the 12 domains, whereas the lighter blue correlates with preemptive laws in fewer of the 12 domains. Next slide, please. In the second year of the project, the team expanded the dataset to be longitudinal. This allows viewers to see laws become effective as all the way down to the date that they were effective. Additionally, based on subject matter expert feedback, the team expanded the substance to include implied preemption captured in case law and attorney general opinions. They refined the municipal broadband domain to capture legal barriers to municipal broadband in addition to the express preemption already included. And they expanded the scope of the ban the box and rent control domains to include statewide regulation or a lack thereof, where the states preempted local governments within those domains. This helps to capture where there are vacuums in these types of regulations, a topic that Amy just touched on briefly, where the state prohibits local regulation, but also does not regulate it at the state level. A common theme that we found in our expansions was the importance of capturing implied preemption in addition to the express preemption originally included. Next slide, please. The project added 4 additional domains in 2022 and 2023, while also updating the existing domains through each project period, except that the 6 tax domains were removed and not updated in the final iterations of the project. Next slide, please. So with that brief overview of the project, let's look at some of the key findings we observed over the years of our project. We will talk about 4 categories of trends that we saw in different domains in how preemption was passed across the country. Next slide, please. There were certain domains in which we really saw very little movement over the 6-year project period. For example, ban the box preemption became effective in only 1 additional state, Texas, during the project period. You can see that represented in the maps on the slide. Next slide, please. In other domains, we saw a more gradual shift. As an example of this, we can look at the paid leave preemption domain. Here, the overarching question we examined was whether the state law preempts local governments from mandating employers provide paid leave to employees. You can see the states that preempt local mandatory paid leave laws in red on these maps. And then if you look at the graph below each of the maps, you can see an image of the rise or fall of the number of states coded yes for this question over the course of the entire project period. If you look very closely, and I know it's small on these slides, but if you look very closely at the graph, you can see that the number does go up from 2019 to 2024, but only gradually. So as you can see in our original data set as of August 2019, which is on the left, the map on the left, 26 states preempted local mandatory paid leave laws. That number went up by 3 states by December 2021. Then the following year, from December 2021 to December 2022, there was no change. So first year, there was 3 additional states. Second year, no change. Next slide, please. But then from December 2022 to December 2023, there was another jump by 2 states. And again, no change from December 23 to December 24. So paid leave preemption has had a steady but slow increase over time. Next slide, please. Another type of trend that I will touch on was in domains where we saw a flurry of action in a short period of time that then sort of tapered off. So for an example of this, we can look at the race and racism in school curriculum domain. Here we looked at the state laws that preempt local policies regarding school curriculum and whether the state law prohibits specific curriculum. To learn more about which specific curriculum are prohibited, you can look at the additional questions on Law Atlas, but for purposes of this demonstration, we'll look at these 2 questions. As of August 2019, only 1 state had a law preempting local policies regarding race and racism in school curriculum, and that 1 law did not prohibit a specific curriculum. Note here, this 1 law was in Arizona. It was found unconstitutional in 2017, which is indicated in the dataset as a caution note, but it remained on the books, which is why you can still see it here. Next slide, please. So the first state in which such a law became effective outside of the unconstitutional Arizona law was in Idaho on April 28th, 2021. Next slide, please. By January 2022, just 9 months later, 9 additional states passed laws regulating race and racism in school curriculum and prohibiting specific curriculum. This count now includes a new Arizona law that was not found unconstitutional. So Arizona is counted now. Next slide, please. By January 2023, 3 additional states prohibited certain curriculum related to race or racism. And then next slide. Then by January 2024, 1 additional state, and by December 2024, another additional state enacted these types of laws. So we still see states passing these laws, but not quite at the speed that we were seeing in 2021 to 2022 when we saw 9 states in 9 months. Next slide. So I will pass it now to my colleague Adam to talk about what we saw in transgender rights domain.
Hi, everyone. As Lauren mentioned, in 2022, we decided to expand our scope and we added transgender rights to our preemption project. And I think this was particularly important because one thing we noticed in the trans space at the time was that there was a lot of new regulation coming out. That exploded in 2022 and exploded more in 2023 and more in 2024, and it's continuing in 2025. But what I kind of realized is one of the inroads they had to doing all of that regulation was through this preemptive mechanism. So if we go to the next slide. In 2019, we saw 3 states that were expressly preempting. Arizona, I believe, had a requirement on disclosures of transition in schools. Arkansas and North Carolina both had what we typically think of as express preemption in the trans space. The prohibition of adding new protected classes to anti-discrimination statutes. North Carolina was also still suffering from the kind of legislative imprint of HB2, because even though in 2016, 2017, there was all that litigation in North Carolina about their bathroom bill, well, the court cases didn't completely remove it. So here in 2019, we have those 3 instances of preemption. Next slide. By 2020, it had jumped to 4. Idaho came in with a sports ban that was doing the same thing. But then, next slide, 10 states by 2021. Next slide. 20 states by 2022. Next slide. 23 states by 2023, and then 1 more in 2024. So we can see this incline is pretty egregious. And my theory has always been that preemption was kind of the way in the door. If we go to the next slide, because one thing that we need to know about this kind of express versus implied distinction in trans rights specifically is that a lot of these ways in which there could be express preemption can get kind of technical. So typically things like school curriculum or medical law, as in gender affirming care, those are the rights of the state. The state has the power to regulate those domains. So them doing any kind of regulating is inherently preemptive. But what we found is there's particular ways in which they are preempting that is more explicit. So for an example, the first state with a ban on a gender affirming care did so through preemption. This was Arkansas in 2021, I believe. And they did so by withholding any or prohibiting the use of any state funding going to gender affirming care. So it kind of like turned into an affirmative, or it turned into a preemptive mechanism. If we go to the next slide, what we also know though is all of these states are just regulating in those spaces, and that serves as preemption as well. Whether it's single sex spaces, defining biological sex itself, inclusive school curriculum, or so on. These functions work to preempt localities from regulating or kind of allowing for the proliferation of transgender rights. Next slide, we'll see this kind of trajectory with one subject in particular. So single-sex spaces, on whether or not they're regulated at all. Not just if there's a preemptive mechanism, just whether the state is regulating single-sex spaces in some capacity that impacts transgender rights. Again, because of HB2, North Carolina was still regulating single-sex spaces in 2019. Next slide. we skip 2020 because there's no movement, but by 2021, a second state was there. Next slide. By 2022, 4 states. Next slide. 10 states in 2023. Next slide. And 13 states total by the end of 2024. So we can see this trend is similar to the trend of preemption as a whole, because what we're noticing is preemption is kind of this legal maneuver to kind of get in the door. It's a convoluted legal mechanism that not everybody is kind of privy to. So people think, oh, that's just the legislature doing their job. Okay, cool. But then once that's kind of in there, they start to regulate as a whole. And what we see next slide is the kind of product of that. And that is gender affirming care bans over time. Those preemptive mechanisms for 10 states are usually funding prohibitions or maybe something related to a state level hospital. But then what we've saw was an explosion in gender affirming care bans, where 25 states in total are just banning gender affirming care rather than doing so through a preemptive mechanism. And that's kind of the big picture trend that we've noticed with trans rights, is this ability to use preemption as kind of the foothold in terms of regulating in the space altogether. And then we can go to the next slide.
Thanks, Adam. Turning it over to you now, Ben.
Thanks a lot. Good afternoon, everyone. My name is Ben Hartung, and I'm a public policy advisor with the Division of Chronic Disease and Injury Prevention at the Philadelphia Department of Public Health. I'm going to be discussing a project that I worked on with staff at the Center for Public Health Law Research and staff across the health department on policy surveillance of firearm regulation in Philadelphia. So the background for this is that one of the core areas of focus in my program at the health department and injury prevention is focused on trying to reduce firearm related harms and deaths in Philadelphia. And as I'll explain, Philadelphia has been preempted by Pennsylvania state statute for many decades now, and collaboration between health department employees and the center led to a project to try and estimate the impact of preemption on firearm deaths in Philadelphia across a 20-year period. So I can start with some background. Next slide, please. So going back to the initial explanation by Amy, Pennsylvania is a home rule authority state. And so Philadelphia has its own home rule charter, which allows it to pass regulations on anything that hasn't been touched on specifically by the General Assembly. So the General Assembly is allowed to prohibit Philadelphia from legislating in certain areas if it so wishes. I'm also including some constitutional amendments on here, articles I should say, because the greater context for this research project was the city of Philadelphia a few years ago mounted a constitutional legal challenge to the Pennsylvania state firearm preemption statute in an attempt to get that firearm preemption statute overturned, basing that argument on the fact that the preemption statute is prohibiting Philadelphia from protecting its citizens in a way that allows them to fully articulate their rights under Article 1, Section 1. So Philadelphia has a higher rate of firearm violence than any other municipality in the state. And, you know, the argument is that without the ability to control firearms locally, we're not living up to our constitutional and home rule authority bargain for the citizens of Philadelphia, which I can explain a little bit more as we go on. Next slide, please. So specifically, the preemption statute that I've been referencing here in the introduction is the Uniform Firearms Act. That's a Pennsylvania statute that limits the regulation of firearms and ammunition, and the specific code language is that no county, municipality, or township may in any manner regulate the lawful ownership, possession, transfer, or transportation of firearms, ammunition, or ammunition components. when carried or transported for purposes not prohibited by the laws of the Commonwealth. Sorry, that's a mouthful. And so this is pretty much an express preemption statute that has been interpreted several times over the years by Pennsylvania courts because Philadelphia City Council has continuously tried to regulate firearms in different manners to get around this preemption statute. And so I'll get into this more later, but there's, lost and stolen ordinances, handgun purchasing restrictions, licensing requirements. All these have been passed by City Council and to one extent or another have been litigated to be preempted or have been considered by the city to be preempted based on the interpretation of other court cases. So the general effect of the court jurisprudence is that we've sort of entered into a field preemption situation in terms of firearms in Pennsylvania. So anything that is on the books in Philadelphia related to firearms right now, with the exception of a couple recent wins, is considered to be preempted. So our project looks at a 20-year period, and I can go into more specifics about that in a few minutes, but I just wanted to set up sort of the public health background for why we're interested in this project. Next slide. So here is a graph showing the firearm crude death rate per 100,000 people in the United States, which is the light blue line versus Philadelphia County and the dark blue line. And as many of you may be aware, Philadelphia has a much higher firearm death rate than Pennsylvania, as I mentioned, and the country as a whole. Luckily, we've seen some reductions in this rate since 2021, but from a public health perspective, the firearm death rate in Philadelphia is still unacceptably high. You can go to the next slide, please. And from a local public health perspective, there's a health equity issue here in that gun violence in Philadelphia disproportionately impacts Black men. And so the inability of Philadelphia City Council to regulate firearms in a more restrictive manner than the state has allowed us under the Uniform Firearm Act has a disproportionately burdened Black men from the city's perspective, in that we can't enforce our own laws. And so firearm regulation in general is an evidence-based approach to reducing firearm mortality, and studies have shown that you can achieve up to 11% reduction in gun deaths by implementing more restrictive gun policies. And so, next slide, please. The research question that we came together, and this was with epidemiologists at the health department, data scientists. I'll shout out Giselle Babiaris, who is one of the data scientists who helped us, and she's on the call listening today. Our research question was, if Philadelphia had not been preempted from enforcing local gun laws over the past 20 years, how many deaths could have been prevented? Next slide, please. So here's a partial timeline of the Philadelphia firearm ordinances that we collected. And so this is the sort of legal surveillance portion of the project. Myself, along with some legal interns and Amy Cook at the Center for Public Health Law Research, compiled a list of ordinances that were passed or in effect between 2001 and 2020 in Philadelphia, and categorized them by subject matter to make sure that none of the ordinances were counted twice, because, as I mentioned, the City Council in Philadelphia has passed laws numerous times attempting to evade preemption. And so some laws are on the books a couple of times at the same subject matter. So this is just demonstrating, how much activity there is at the local level in a timeline fashion. Next slide, please. So this graph here that you see is the culmination of some modeling that was done by our research scientists based on the legal epi that I performed with Amy and our legal interns, and this was presented at the National Research Conference on Firearm Injury Prevention. So the way that this study worked was that the EPIs and data scientists collected firearm mortality rates from the CDC, demographic characteristics, and across states, and they also used a firearm state level policy surveillance project that was done by Michael Siegel at Boston University. So the baseline for this study is that we had information about state level firearm death rates, and we could compare them to the amount of state laws that were on the books across the country. And as I mentioned, the public health law research shows us that the amount of firearm laws you have on the books is correlated with a lower firearm death rate. So firearm regulation is effective in that if you pass firearm laws, you will have a positive public health outcome. So using that, evidence base, what we did was develop a novel database of attempted municipal ordinances in Philadelphia from 2001 to 2020. So that's the timeline of ordinances that I showed on the last page. That informed the amount of laws that would be missing in Philadelphia. And so what we did, what I didn't do, excuse me, what the data scientists and EPIs did was they created a multivariable model of mortality, firearm laws, and demographics. Like I said, using the state level data and CDC data as a baseline, and then translated that into an analysis of what would have happened if Philadelphia had had these 26 ordinances that we identified as preempted on the books. And we determined that without preemption, there would have been 541 fewer deaths across this 20-year period, and that would have been 1.8 fewer deaths per 100,000 people in Philadelphia. So this is still research that we're working on. And next slide, please. Sorry. And we hope to continue to make improvements and updates to it. So I just wanted to present some project takeaways and next steps here. So the lessons learned from this is that legal epidemiology can help us model the health impacts of preemption, as we demonstrated by collecting, comparative level state data and translating that to the local level. We could show that there is likely a significant impact of health protectiveness of firearm laws in Philadelphia. Another thing that we learned pretty quickly is that local data sets are different than state level data sets. Local data sets are more research. They present research challenges in that you can't use Westlaw. You have to go right to primary sources. So they're more resource intensive. Excuse me, it's like a tongue twister. That is something that you should take in consideration when you're working on local laws. But as we demonstrated, it's a useful tool because it allows you to show the relationship between local regulation, preemption, and mortality, and make arguments for why state legislators or courts should determine that preemption is not a good thing when dealing with issues of public health prevention. So a final thing, that we've learned, at least so far, is that working with a multidisciplinary team, lawyers, data scientists can really help guide a policy surveillance project by helping to inform the question development process and the coding protocols. One thing to note is that in our current project, there's no sort of detailed level classification of the subject matter of the ordinances that are preempted in Philadelphia. And that's something that we're trying to do right now. And it's through a complete longitudinal data set that we're hoping to have published at some point. But I'm working with Amy Cook and some legal interns to keep that project moving. And then something else we'd like to do in the future is expand this beyond Philadelphia to compare it to other jurisdictions to see if we can get similar results, or to see if there's differences between the amount of, preemption or the type of preemption in other state local situations that informs the research that the EPIs and data scientists have already completed. And next slide, please. And I just wanted to note that there's been, like I said, extensive litigation on this topic. And I don't think I'm gonna have time to go through these because I want to save time for our other presenters. But next slide, please. At the Pennsylvania state level, we have a divided House and Senate, and the Pennsylvania House has recently passed several bills out of committee and out of the full House that would improve firearm regulation in Pennsylvania, but they have not been heard at the Senate at this point. Next slide, please. And finally, bringing this back to a public health context, I just wanted to note that there's, regulation of firearms isn't the only way to prevent firearm harms and deaths. We know that the social determinants of health are also related to firearm injury. And so just wanted to show some of the data that we have on our Philadelphia Department of Public Health website that compares the unemployment rates and census tracts to the current fatal and non-fatal shooting victim counts. And as you can see, they track pretty well. So regulating firearms is not the only thing we can do. And since Philadelphia cannot at the moment regulate firearms, we have to think of other ways to improve public health. And I'll stop there. Thank you.
Thanks so much, Ben, for those insights. I will turn it over next to Brianne.
Thank you. Hi, everyone. I will warn, I've been having a little bit of internet problems, so if I go off camera or suddenly freeze up, that is why. But good afternoon, Brianne Schell. I co-lead the legal team at the Local Solution Support Center, along with my colleague Leslie Zellers, who I'm sure some of you may know, public health space. For the next couple minutes, I'm going to talk about how LSSC tracks state preemption for practical purposes and how we use our tracking and others tracking efforts to support our partners, advocates, and policymakers. And a quick little caveat is that our tracking is a little bit different from like what Lauren and Adam were talking about, where they were tracking laws that are on the books and being adopted. We also track bills being introduced, whether they pass or not. So yeah, next slide, please. The Local Solution Support Center is a national hub that coordinates and creates efforts to counter the abuse of state preemption. We do this through a number of internal teams that work both independently and together. Each team represents kind of a way that we can use our tracking for practical purposes. Our tracking kind of helps inform the work of each team in one way or another, just as they inform our tracking. Our state campaigns team supports cross-movement collaboration by providing dedicated support to locally led coalitions and advocates in a handful of target states, which can shift as individual states' needs and priorities shift. Our home rule team, which does not have its own graphic on this page, unfortunately, also works with kind of variable target states to try to modernize outdated home rule laws so that local governments have the power that they need to protect their communities. And the research team demonstrates the consequences of abusive preemption by curating research and connecting a network of academics and researchers to state and local advocates and campaigns, helping them show lawmakers how the real world negative consequences of abusive preemption show up. Kind of similar to what Ben just got finished talking about. They would be the ones who would also be trying to figure out like how many deaths has this preemption led to, preemption of firearm regulation. And then the communications team creates the public imperative for reform by communicating with reporters, managing our social media, and packaging all of our written materials and information for our website and other audiences. You can go to the next slide. Last but not least, of course, the legal team. Leslie and I are responsible for the tracking of abusive state preemption across all 50 states and DC. And we also conduct other legal research with other members of our team, prepare memos and white papers, support litigation efforts with strategy sessions and amicus briefs, and connections to subject matter experts, which we employ. Next slide. So I keep using the term abusive preemption. That is really our focus at LSSC. While preemption can sometimes be used for good, like by setting minimum standards for health and safety and civil rights, we focus on the bad kind of preemption that seeks to limit local democracy and target marginalized communities, as everyone has been discussing so far today, targeting communities like LGBTQ folks, working people, immigrants, racial minorities, all sorts of people. So next slide. We track abusive preemption in 15 different categories, including, for example, the ones you see on your screen: public health, workers' rights, voting rights, education, LGBTQ rights, and prosecutorial discretion and policing. We also have a miscellaneous category that we use to track emerging trends, track emerging trends like preemption of local broadband networks, and some hyper-specific one-offs like bills preventing cities from flying pride flags at government buildings, or from preventing them from taking down or moving Confederate statues. And tracking bills in these different categories helps us identify trends. So for example, we saw about a 900% increase in how many anti-immigrant preemptive bills were introduced so far this year compared to all of last year, 2024. So if we, next slide, please. So what do we do with our tracking and the trends that we identify? If we have strong connections with partners in a specific state and we find a bill that may be of special interest to them, we reach out and we say, hey, you may want to have this on your radar. I know you guys are working on this. I mentioned a couple slides ago that our state campaigns team might use our tracking to identify which states are introducing the most oppressive bills, who needs the most help. Our research team might use the topics to identify which areas may require more research or be more timely for research. And our communications team can inform reporters about trends and have like specific numbers and examples to back them up. And then, of course, the legal team, we also inform our tracking based on the insights of our colleagues on the other teams and partners on the ground. On this slide, we have some of our written resources we've created based on our tracking in collaboration with our communications team. Front and center is our most recent publication, our 2025 legislative session overview, highlighting how states are using preemption to carry out the federal administration's autocratic agenda. Our communications team also hosts reporter roundtables to discuss these written products and other tracking and trend information with reporters. And reporters will often come to them with specific questions about our tracking based on what specifically the publication they work for or their local community is interested in. All of these can be found on our website. I'm happy to send links to anyone, but they should be easy enough to find, hopefully. So I've already touched on the trend analysis we do with our tracking. Oh, I'm sorry. Next slide, please. I've already touched on some of the trend analysis we do, looking at which states are introducing the most bills, what topics they're covering. We also look at how many are actually passing. Some newer, quote unquote, hot topics in preemption, like immigration, may have a ton of bills introduced, but a low pass rate because it's a less familiar topic for some states. Like I'm in Ohio, we don't necessarily have a big immigration problem, right? We're not near any borders. So legislators are less familiar and they may want to wait and see how things play out in other states first. And it might take a few years of introducing bills that fail to kind of finally get momentum. On the other hand, we've been seeing like public health authority preemption spike since COVID. So now 5 years in, there are fewer bills introduced, but a very high rate of passage because we've been talking about them. And Ben talked about firearm preemption. We see barely any bills introduced in firearm preemption because most states already have those laws in place and have had them for a long time. Some bills are also introduced just for virtue signaling and won't pass, like a bill banning trans girls from girls' sports in schools is probably not going to pass in a deep blue state like California, but the legislator who introduced it does so to kind of take a side publicly. Alternatively, some bills are just so extreme. I don't have time to give crazy examples, but happy to share if anyone specifically wants to know. Some bills are just so extreme that they're unlikely to pass even in some more conservative states. But we found that it's just as important to look at what doesn't pass to see where our local advocates are having success in either striking them on defense, like on preventing them from passing, and also to know what might be in store for coming years. In fact, we have a whole section in our most recent, our 2025 legislative session report about what we're anticipating for next year, given this year's trends in the federal agenda, to try to prepare advocates. And in addition to the analysis we do based on our own tracking and identification of trends, we also get a lot of technical assistance requests from partners that we use our tracking capabilities to respond to. It could be as simple as an abortion advocate asking for a list of all of the preemptive abortion bills introduced this year in, their target Midwest states. That's easy, it's quick. We send them what we have. Or a local organizer could come to us and say, hey, my state is trying to prohibit local governments from granting permits for public protests. Is anybody else doing that? Other states? What do their bills look like or their laws? Have any other advocates been able to defeat this? So we would then use our tracking software to try to find bills similar to the ones they were asking about and provide any other information we could. Then in that case, we would connect them with our contact at the International Center for Nonprofit Law, which has a dedicated protest law tracker and would likely be better equipped to answer their specific questions. Tying it back to my other fellow presenters, we also refer people to Law Atlas occasionally. So if we don't have all of the information or we don't have an expert, we try to send them to somebody who is. And then just as important as the subject of the preemption is the scope and the enforcement of the preemption. Ben touched on this with legal interpretations of how broad the Pennsylvania law is. So by analyzing the bills we track, especially in the specific political context of the states they're being introduced and passed in, we can help our local partners understand what they're up against and how they can respond. Our state campaigns and communications teams can help them with their advocacy and communication strategies to defeat a bad bill. Or we can tap into our team of legal experts to provide advice and support on challenging a bill that becomes law. And lastly, even where litigation is a possibility, oftentimes local governments and advocates may not have the resources or the political appetite for litigation, and they may face a steep road of unfriendly courts. So we've also identified through our tracking instances where states retaliate against cities for launching legal challenges. For example, Texas passed an extremely broad preemption law that we refer to as Death Star preemption in 2023. Locals challenged the law and they saw some modest success in the courts. It's still kind of ongoing, but they temporarily delayed implementation. And in response, this year, the Texas legislature introduced a bill that would have dictated how state courts interpret state laws that are being challenged by local governments, effectively trying to nullify the authority of one of the branches of government in cases where their authority was questioned. That bill luckily failed, but it does help us inform by tracking it. It helps us inform what kind of support we can provide to partners in Texas and elsewhere with these very hostile legislatures, to say the least. And that's something that we will keep an eye out for in our tracking in future sessions. So hopefully that leaves enough time for questions. If you want to go to the next slide. Just some contact information on our website and stuff. And I look forward to the Q&A.
Thank you so much again to all of our speakers today. I feel like that was a lot packed into about an hour. I know I have some questions for you all, but I want to make sure folks have the opportunity to ask questions. Again, you can use the Q&A function in the Zoom toolbar. It looks like we have one question. I think probably several of you could answer this. It's, I think, one of my favorite topics to talk about, but the question is, did ALEC or a similar body have any role in spreading so-called model legislation? Why so much foment all at once? Anyone want to take that question?
I can comment briefly. We get a lot of questions about ALEC, and it is hard to say 100% sometimes whether they were the ones pushing something around, but we can usually figure it out by looking at bill language. It's if they send a model bill to someone and they barely change the language and we find it introduced in 17 legislatures in 2 years, usually we can kind of guess that they were the ones pushing that around. And it is not uncommon. I think based on the timing of that question, it was probably about the LGBTQ bills. And so I would guess yes, but it's hard to say for sure. You just have to look at the language.
Thanks, Brian. I think I have just kind of a follow-up question to that, if you don't mind, or if others want to chime in. I think this is something that folks who are in this space and are well aware of preemption and what's happening at a broad level, or specific to certain policies they may be working on, understand the role that groups like ALEC and others play in terms of like drafting these kinds of model bills and pushing them forth. Do you think, as far as like the general public goes, do you think there's an understanding of organizations like ALEC and what they're doing? That's something I'm always curious about. I know that there's a lot of grassroots efforts to educate the public about what preemption is and how it's impacting them. I'm curious if you think that this is something that's like widely known, or if it seems to be something that's like really just within this space. If you're working in preemption, you have an understanding of it.
I can quickly answer that too. I think probably not. Maybe they've heard of ALEC as a organization in the general public, but I wouldn't say that there's a broad understanding of what they're doing and how prolific it is, because even I didn't realize it until a few years into being a lawyer, so being and in the policy space. So also I think the general public just doesn't usually have an understanding of preemption, because like we talked about, it is kind of a complicated legal mechanism. Nobody usually knows what I mean when I say it, and I have to give an example. So
yeah, no, I think, and I imagine some of that is intentional, right? Like, I think the goal is so that people don't know who's behind a lot of these model bills. And yeah, I think that's important to think about. Looks like we have another question. Robert Osme, hi Robert, asks, we have another law that we refer to as Death Star preemption that was passed in Florida in 2022. Ours specifically enables legal challenges by companies who feel as though a local law has or will have a negative impact on their business. I'm curious what kinds of trends you are seeing when it comes to that type of preemption. Is this becoming more common? Are there other mechanisms for preemption that might have a similar impact? Thanks for that question.
yes, we are seeing a lot of that, where the state is giving either private individuals or, like you mentioned, businesses the legal ability to challenge local laws that they just don't like. I mean, I can't think of numbers or specific examples, but I've seen so many where it's like you can challenge a local elected official and put them up for review and removal from office if you disagree with something they did, like with some very broad language, like, oh, I don't like that, so I'm going to challenge it. And they put this mechanism in place for the state to review. There's another one that came to mind. A couple laws. There's one in Tennessee. There's one in Tennessee that allowed, I think it passed this year, allows the Attorney General to investigate any local law that any state legislator doesn't like, like thinks might violate the Constitution. The Attorney General will look at it and they can strike it down that way instead of going through the courts, kind of giving them like a back alley way to strike down local laws with very little legal process or very little traditional legal process. Happy to follow up with you if you want to talk more about that, but yes, the short answer.
Thanks, Brian. It sounds like this one may also be another question for you. State lawmakers in bill to preempt rental registries last session. We're anticipating seeing it again. How do we prepare?
Yes, I'm going to say off camera. My internet acted a little weird there, but our colleagues at Local Progress, if you look up Local Progress, they have been really focused on the rental registries. So I would reach out to them if you want kind of more directed help, but that is one of those where it's kind of a small thing that a couple states started thinking about and that we are anticipating is going to kind of explode. And yeah, we've also been seeing a lot of, just generally speaking, housing preemption that heavily favors landlords and disadvantages renters. So happy to set up the connection with my colleague at Local Progress if you'd like. Just shoot me an email.
Thank you. Looks like we might have time for one more question. Thank you to those who asked. I think there's a lot going on with preemption, especially right now. So yeah, this is, even in our own work, I think something that we're seeing is like swiftly evolving, and trying to stay on top of it can really be a challenge. For Ben, do your program have any plans to disseminate your findings? I imagine this kind of evidence would be very helpful for those advocating for firearm regulation.
Yes, we did publish the preliminary findings in a journal, and I can share that if with the presenters here, and maybe we can send that out. But yeah, the larger goal is to do a something that can be published in a journal, but the initial results are available publicly.
Thank you. I think we have time for one last question before we hop off, and I will invite maybe my colleagues to share some thoughts. How to prepare best in law school, or their experience to do preemption law, especially around human rights. I think that can really depend on what area of law you plan to go into, but anybody have some thoughts to share? Or I know there's lots of lawyers on this call, so.
I hate to answer like all the questions, but I sent a private message to the individual. Any courses about like separation of powers and federalism and local government law, anything where you can kind of understand authority between state, federal, and local is great. And then yeah, civil rights, obviously. And I see Adam turned his camera off, so I'll go ahead.
Yeah, I want to add to that they're not as glamorous, but legal theory classes can really help. One of the tricky things about preemption is like conceptualizing what it is, what it means, how it kind of can have an impact. And once you really understand that, that's when we get into the like why this is so useful in terms of better public health law, is because local law happens to be where so much progress is made. And then these limits are kind of structured in such a way that makes it harder to enact or act in general.
Thank you. Thank you again to all of our speakers today. It was great hearing from you, learning more about preemption as it relates to legal epi and seeing what it looks like in practice.